So, Renato, can the president really pluck people off the street and just send them to a prison in El Salvador?
It's complicated.
I'm Asha Rangappa. I teach national security law at Yale University. I'm a former FBI special agent, and I'm a legal contributor for ABC News.
And I'm Renato Mariotti. I'm a former federal prosecutor, a practicing lawyer, and a legal analyst.
And I'm Steve Vladek, and I teach at Georgetown Law School and write the Supreme Court Substack One First.
And we're here to help you understand topics that can't be boiled down into a soundbite or a skeet. So I'm really excited that Steve is here because, so among other things,
things have always gone badly when I show up, right? Like it's
Right.
never good news. Like, hey, unicorn, Steve is here.
No, things are always really, really bad when we have to get on the bat phone for you. But also I'm excited because, I teach national security law and the case book that I use is written by Steve. So basically, everything I know about these topics comes from Steve. And I think, Renato, we're often quoting from his One First Substack when,
Absolutely.
we're talking about things before they get to DEFCON 1 and we have to actually just get him here.
Absolutely. Yeah. Steve is such a great resource. It made absolutely no sense for us to try to badly explain what Steve is saying. Let's get this right from the horse's mouth. And
I can badly explain it myself.
So we're back talking about removing people from the country. Renato and I discussed this last week with regard to Mahmoud Khalil. Is that right? His name?
Khalil. Yep.
Mahmoud Khalil, who was removed or I guess arrested at Colombia and is in removal proceedings. And that was all happening under a provision of the Immigration and Nationality Act. But we're back talking about arrests and removals under a completely different authority, the Alien Enemy Act. And so let's just start there. Maybe you can just quickly, I don't want to go down the rabbit hole that we went down last week with, Khalil, but just kind of the distinction and what the statute that we're talking about today says.
Sure. So the Alien Enemy Act of 1798, it's an oldie but a goodie, is basically meant to give the president the authority during wartime, and we'll talk a bit about whether this is wartime, to arrest, detain, and potentially remove from the country individuals for no other reason than because they are nationals of the country with which we are at war. And so, enacted before we had any of these immigration laws, the idea was like, here is a sort of suspicionless basis for just, picking people up off the street if it's wartime. Because if we're at war with Great Britain, maybe we don't really want all of these British subjects running around Washington. That was the idea. It was how it was used during the War of 1812, during World War I, and during World War II. And it hasn't been used since. And so, we have this remarkable invocation of this statute by President Trump, which he's, invoking purportedly to use against any male 14 years or older who is not just a Venezuelan national, but is a member of Tren de Aragua. And so, this raises, I think, sort of two massive questions, like the facial question, are we at war with Tren de Aragua? And then the sort of more specific question of, even if we are, what kind of process, if any, are folks entitled to before we put them on a plane and ship them off to El Salvador?
This reminds me a lot, Steve, of the quote war on terror, when we essentially had people who were, obviously there's a very famous case, the Padilla case, a U.S. citizen, but there are others, right, who were suddenly taken, and it was really the executive branch making decisions on its own about who was at war with the United States. I mean, what process is someone entitled to if, for example, the administration decides that there's someone who is effectively part of a group that is at war with the United States?
I mean, it's Renato, it's such a good example to bring up the post 9/11 cases because there was, as you guys both know, a robust jurisprudence that developed where the government had to prove in individual cases that individual detainees were part of, right, members of Al Qaeda or its associated forces, and so this, provoked a very how do I say, intense back and forth litigation, not just over Jose Padilla and Yasser Hamdi, the two U.S. citizens who were held as enemy combatants, but over the, many hundreds of non-citizens who were held at Guantanamo. And a lot of those guys won their habeas cases. They had judicial review. They were able to say, no, we're not part of Al Qaeda, or at least the government hasn't produced enough evidence suggesting that we are. And, guys, what's striking about those cases is those were folks who were picked up, overseas, some of whom were picked up in active combat operations overseas. And they got that kind of review, right? Here we have the Trump administration picking folks up off of US streets or plucking them out of immigration detention in the United States and saying that this 1798 statute gives it the authority to summarily remove them without individualized process. I mean, that distinction is, I think, striking and, to me, positively alarming.
I want to unpack a couple of things that you mentioned just so that our readers understand some of the different legal concepts that we're talking about. So in the War on Terror, Bush was operating under the 2001 authorization for the use of military force. So he didn't invoke the Alien Enemy Act. He didn't need to because there was an, albeit vague, but still a designation of an enemy of the people who kind of helped with, in the attack on the United States. And as you mentioned, he used that to essentially categorize people or designate them as, quote, enemy combatants. And basically, the litigation that you're referring to was sort of like, he was essentially saying that's the end of the story. Like, once we determine that somebody's an enemy combatant, that's it. It's not reviewable. But you also mentioned habeas, which is the process by which someone gets their foot in the door of a courtroom in order for the government to actually explain the basis of the legal detention. And the Bush administration also tried to prevent these detainees from having that, right? Like, they really tried to, the original reason for sending them to Guantanamo was to basically put them out of the reach of the courts, which did not work out so well for the Bush administration. But can you walk through just kind of the importance of habeas, just the ability to get your case in front of a judge who might, by the way, say, okay, yeah, President, you're totally legit, and then send you back to your jail cell. But can you just talk about that particular liberty right? Because I think that is truly what we're talking about here before we get to, the process and how we determine who somebody is.
Yeah, no, I think that's right. I mean, and keep in mind, it wasn't just President Bush. It also eventually was Congress that tried to cut the federal courts out of the loop in the Guantanamo habeas cases. I mean, in the Military Commissions Act of 2006, Congress actually tried to take away the habeas jurisdiction of the federal courts. So the writ of habeas corpus is one of these old common law writs that, really comes to full form in 17th and 18th century English courts. And at a time when really there weren't necessarily that many substantive rights against the crown, habeas became a right unto itself, where the idea was that, even if the government has the power to detain you, you, the individual, have the right to, have a court say so, right? That the courts are the ones who get to pronounce on that and not just the executive by fiat. And so that's why, we spent so much time in the Bush administration fighting just for the basic idea of judicial review. We can have the messy conversation. Are we at war with Al Qaeda? What does that mean? What does it mean to be a member of Al Qaeda? What authority does the government have to interrogate these? All those sort of substantive questions were subsidiary to the question of who's going to answer them. And, we really settled that in the context of the Guantanamo cases because the Supreme Court in 2008, in a decision called Boumediene versus Bush, said, at least for the folks who are at Guantanamo, the suspension clause of the Constitution, which protects against suspension, the privilege of the writ of habeas corpus, quote, unless in cases of rebellion or invasion, the public safety may require, unquote, the elimination of habeas. Right. And so the Supreme Court says, listen, that means you get a robust, meaningful hearing to contest whether you really are who the government says you are. And I have to say, guys, like, I find that piece of this so much more offensive than the, we are at war with Tren de Aragua. Like,
100%.
I'm troubled by applying this statute to Tren de Aragua because this statute is much more specific than the AUMF was. But, that's the substantive authority question. The notion that, like, the president can just say, hey, that guy's in Tren de Aragua, or that guy, or this guy, right? Like, that's why no matter what you think about the substantive authority, we should all be on the same page that, like, this is why we have habeas. This is why we have judicial review. And just really quickly, this is why even in the middle of World War II, when we held German nationals under the Alien Enemy Act, they got judicial review too.
So where does that piece of it stand? I mean, obviously the court is exercising its jurisdiction, but these people are in El Salvador. So I'm really not sure what kind of meaningful habeas review they're getting because, I mean, does it get all complicated now because they're kind of out of the habeas is sort of, it's about the court basically tells the jailer, hey, you need to show up and tell us why you're holding this person. But the jailer is now the president of El Salvador.
So yes and no. I mean, yes, to go, it would be a great name for a show. It's complicated, right? But to go back to the top for a second. So a federal judge in Washington has no power over a Salvadoran prison commandant. But right, and here's the but But federal judges do have power over the U.S. government. And so insofar as the claim is that these folks are being held in El Salvador at our request, and indeed with us paying for it, which I think is at least what the Salvadoran government has said, then federal courts do at least have the power to tell the U.S. government to knock it off. And there's a great case about sort of something like this from 2004. There was a U.S. citizen named Omar Abu Ali, who was picked up by Saudi intelligence officials and held in Riyadh, where he was being interrogated. He claimed he was being tortured. And his parents brought a habeas petition on his behalf in D.C. And their argument was that the only reason why the Saudis had picked up this guy and the only reason why the Saudis were interrogating this guy was because we had told them to. And Judge John Bates, who is, a George W. Bush appointee, like not a bleeding heart, said, listen, if that's true, and, we'll have some discovery to find out if that's true, but at least if that's true, I have the power to tell the U.S. government to knock it off. So maybe that doesn't mean I can release this guy from Saudi prison, but I can at least tell the U.S. to stop, interfering, to stop being part of it. And surely enough, right after that decision came out, the U.S., somehow got Abu Ali onto a plane where he was brought into the United States and tried in a civilian criminal court on some serious charges. So, no, like Judge Boasberg has no power to unlock the door to the Salvadorian prison, but he does have the power to tell the U.S. to do whatever it can to bring these guys back. And I think really just as importantly, to stop the U.S. from sending more people there.
You mentioned Judge Boasberg for a minute. Obviously, that's referring to a very specific judge in the District of Columbia, federal judge. I believe he's the chief judge right now, appointed by George W. Bush. And there was a hearing, and we can talk a little bit more about that. I'd be interested in your thoughts on that hearing. But he issued an order that, at least temporarily, is blocking further removal of him of individuals without a hearing. However, after that, I thought the reaction on social media by the Trump administration was really something. Essentially, like "oopsie, too late" was the and a lot of guffawing by the Trump administration. I was interested in your reaction there to that and what this kind of portends for future checks by the judicial system and the Trump administration.
I mean, so there's a lot going on here. So there's currently sort of two active strands of litigation before Chief Judge Boasberg. One is about whether the government violated his 2 TROs. So last Saturday, March 15th, Chief Judge Boasberg issued 2 temporary restraining orders. The first one was about the 5 named plaintiffs in the ACLU lawsuit, so 5 specific Venezuelan nationals who he said you can't remove. And then he issued a second TRO after a hearing. And the second TRO was class-wide. It said you can't remove anybody. Right? No Venezuelan nationals can be removed pending, under the statute. And part of what set everything off and sort of raised the level to DEFCON 2 was that there were these 3 planes full of Venezuelan nationals that were in the air, right, while he gave an oral directive to the government to turn the planes around, and they didn't. And so I think a lot of folks took that as like the outright defiance of a federal judge that we've been waiting for. I think it's worth noting Boasberg at least has not, right? He has not yet held the government in contempt. He has been trying to get more information on exactly who knew what when, and whether there was a way, like, was there defiance or was there miscommunication and incompetence? And because it's the Trump administration, you can never be really sure how much of this is malice and how much of this is stupidity. Porque no los dos at the end of the day. But so that's one track, and that's where Judge Boasberg has been pushing the government for more and more information over the last week or so, and is getting sort of increasingly frustrated with them, and the government is making noises about invoking something called the state secrets privilege, but it hasn't yet. And then, guys, there's a second track, which is the government's effort to appeal both of the TROs that were issued last Saturday, and those are set for argument before the emergency motions panel in the DC Circuit, the Federal Appeals Court, on Monday, March 24th. So there's a lot going on here. There's one truckload of questions about whether the TRO is going to remain in place, whether this policy is going to remain frozen. And then there's a second truckload of questions about whether the government's actions last week warrant some kind of judicial censure. And so I think we're seeing movement along both of those axes at once.
So let's talk about the kind of substantive question here and start with this idea, the question of, are we at war? And just to clarify, the Alien Enemy Act also not only says it nationals of a country we're at war, or of a country that, or who have participated in an invasion or a predatory incursion by a foreign government. So, kind of a state-sponsored, I guess, infiltration or something like that. And that, as I understand it, that's the question that's at least the piece that Trump is invoking, that this is an invasion. Yep. But I'm assuming that the question of, are we at war, kind of gets to just the prize cases issue, that whether we're at war is a question to be determined by the president, that no one can question that. And what one would assume that, or the government would say, that it extends to whether we're being invaded. Is that right?
So that's the argument. And it's not just the prize cases, it's also the one Supreme Court precedent about the Alien Enemy Act specifically, this 1948 decision called Ludicky versus Watkins. But Ludicky is tricky because it's clear in Ludicky. So Ludicky was a German national who was being held under the auspices of the Alien Enemy Act, and he brings a habeas petition in 1948 saying, "Hey, wait a second, the war is over. Germany as a country no longer exists, and so by what authority am I still being held?" And the Supreme Court says, "Not clear to us. The war is over." The political branches have not said the war is over. We're not going to second guess them. And so there's, Ludicky certainly stands for the proposition that once you are in a declared war, it is up to the political branches to say when the war is over. I don't think Ludicky is fairly invoked for the proposition that whether we are in a war and whether the jurisdictional predicates of the statute have been met is completely non-justiciable.
And in fact, now that you frame it that way, the prize cases, which was about Lincoln's ability to institute a naval blockade against Southern ports, turned on the question of whether we were at war. And the court
Right.
goes into like this long, like circular reasoning because they don't really want to say we are because it's a civil war, but whatever. But that was the question. I mean, they were actually trying to adjudicate that precise question.
And so, I guess the problem is that there's no clear precedent saying that it is justiciable because we've never had a president try to rely upon the invasion or predatory incursion language. My guess is that the right answer, heaven forbid we try to find that one, is that it should be reviewable with a fair amount of deference. That will defer broadly to factual determinations by the executive branch, but not to legal ones. And so, I think the really heavy lift when it comes to Tren de Aragua is the assertions about its relationship to the Venezuelan government. I don't doubt that Tren de Aragua is up to no good. I don't doubt that, those of its members who are in the United States are part of a conspiracy to be up to no good. Right. But the statute requires, Asha, as you said, that the invasion or predatory incursion be by a, quote, foreign nation or government. And that's where I think, courts might be a little more circumspect about just broadly deferring to President Trump saying so.
It's interesting. I could see a circumstance in which courts defer to the executive having a non-nation state entity at war with the United States. And I think the obvious example is the one that I brought up earlier, right? The Al-Qaeda. Al-Qaeda clearly committed an act of war, you could call it, whatever you want to call it, against the United States, a very horrific act. And ultimately, the bottom line is that in late 2001 or 2002, I would think a court might say, okay, sure, there's a war that we're on against Al-Qaeda, against this organization. I think it's going to be very important for our freedom going forward that courts don't just wave their hands and say this is a non-justiciable political question, which courts sometimes do with certain matters. I mean, I think is that sort of the danger that you're concerned about, Steve?
Yeah, yes. I mean, and I would add there's one other big difference between where we are today and where we were in late 2001. Congress had acted specifically. I mean, Congress, the AUMF, which we've talked about, was enacted, 1 week after 9/11. And although it doesn't mention Al-Qaeda by name, it does specifically authorize the use of, quote, all necessary and appropriate force, unquote, against organizations that the president determines are responsible for 9/11. As the Supreme Court will later say in the Hamdi case, this is the language that triggered the war power. So, I think it's there are, to me, guys, two layers of danger here. Layer number one is too much deference on the war initiation question, right? Too much deference, are we even in a conflict with these guys at all? But I actually am worried too about the retail question, which is too much deference about whether assuming for the sake of argument, we are these guys are still entitled to due process because, Trump did not assert the act against all Venezuelans. He asserted it against members of Tren de Aragua, which means that it's of jurisdictional significance under the act, whether or not you are a member. And, if being a member of Al-Qaeda was a question that required judicial review in the middle of a war Congress had specifically authorized, it should follow that being a member of Tren de Aragua requires no less judicial review in this context.
And just to put a fine point on it, Steve, in the post 9/11 cases, the court said that even foreign nationals being held at Guantanamo Bay who had never set foot in the United States had a right to, and who contested their enemy status, who said, I am not a part of Al-Qaeda, I'm not a part of any of these groups, had a right to have an adversarial hearing in front of a judge where they could contest that status, present their own evidence, and they came up with their own standards. And, as that is an even farther removed and kind of more extreme situation than people who were in this country. And presumably that right gets triggered, I guess, I would think as a matter of course, just by virtue of just being here.
I mean, so there ought to be no question that the folks who we shipped off to El Salvador have at least as much of an entitlement to judicial review as the Guantanamo detainees, and arguably more. I mean, I think there's a remarkable story about how, 23 and a half years in, the federal courts still haven't resolved whether the Guantanamo detainees actually have due process rights. Right, that the habeas litigation was done all as a right to habeas as opposed to a right to due process. But non-citizens in the United States have minimal due process rights. I mean, more and more as their status becomes more and more permanent. And so, the notion that even someone who might be an undocumented immigrant has no right to a hearing before being, removed from this country is just completely belied by the rights that the courts recognize in the Guantanamo cases. And, and that's what I find, at the end of the day, most troubling. Like, even if we're okay loosely with the idea that the government can take aggressive action against Venezuelan gang members, the way that we can tell that the people against whom the actions are being taken are Venezuelan gang members and are not just like political opponents or targets of convenience is judicial review. And that's where I think, no matter what your views are about our policies, like, we should all be on the same page. Like, judicial review is actually how we can have any confidence that this is being exercised correctly.
Right. Just to put a finer point on it, and that's why I started with due process, because to me that was immediately the biggest issue here, is if, as a practical matter, if there's no judge, if you don't have a right to go in front of a judge and force the government to prove that you are an enemy combatant, then as a practical matter, they can decide that, Norm Eisen or Andrew Weissman or whoever they want, Hillary Clinton, as an enemy combatant, and just ship Hillary Clinton to a Venezuelan prison.
And, I realize that folks are going to think that that's alarmist, Renato, but
okay, I don't. Yeah.
Nor I. I mean, listen, the key is, right, this is the whole point. And I wrote about this in my newsletter last week. I mean, Justice Robert Jackson was obsessed with this very idea in all of his late career jurisprudence after he comes back from being the lead U.S. prosecutor at Nuremberg. And he writes over and over again about how, like, due process is indispensable to the rule of law. He talks about how, one of the first real sort of departures from the rule of law in Nazi Germany was arbitrary detention. Right? He talked about how he would much, if put to the choice, right, he would probably prefer to live in a world with Soviet substantive law and American procedures than the other way around. And I think this is what way too many contemporary commentators, not any of us, but like way too many of the folks I see on TV have lost sight of, which is, this is not a referendum on the substance of the policy. This is a referendum on, at the end of the day, who is going to ensure that the government that we've elected in our name is acting lawfully. And, there are lots of reasons why it shouldn't be the government, and why it should be the courts, and why this case has become, I think, such a flashpoint for all of that.
And the Trump administration's argument is basically, well, take our word for it. And it turns out that their word is based on the fact that these people had tattoos.
Right. So take our word for it as part of it. But we've also seen a movement in the briefs, at least before Judge Boasberg, where they're sort of state secrets privilege curious. They haven't quite yet come out and invoke the state secrets privilege, the idea that, like, the government can't be required to turn over national security secrets as part of civil litigation. But what's striking about that is that Congress actually in 1996 created a process for cases in which the government needs to remove a non-citizen based on classified information that it's not willing to make public. And it even created a court that no one's ever heard of called the Alien Terrorist Removal Court as a way of basically balancing the idea that, like, you have a right to judicial review, but we shouldn't have to give up our national security secrets to vindicate it. That process is available. Indeed, until last year, the chief judge of the Alien Terrorist Removal Court was Jed Boasberg.
Right. So this is similar to the FISA court, of which he was also
modeled exactly. It was modeled on the Foreign Intelligence Surveillance Act court. It's just unlike the FISA court, which gets used all the time. We've never used the ATRC. But that's the point again, though, which is you can take seriously the government's arguments, even if you think that they're opportunistic, even if you think that they're retconned, and still think that there's a meaningful way to protect the rights of individual deportees.
Why isn't the existence of that court itself indicative that the Trump administration doesn't have the authority to do this in the way that they did? Like, Congress has expressed its intention, the way it did with electronic surveillance, that if you're going to do this, here's how you must do it. And I think I should add here, we can get into the whole Article 2 argument, but it does seem to me that, rules about immigration and who can be here are granted in the Constitution to Congress. So this, even if it implicates national security, it seems like at best a shared power, that they would have absolute authority to create these courts. So why isn't that itself, why doesn't that preclude the manner in which Trump did this? Like, in what way could he possibly prevail, given that exists?
I mean, it might. I don't want to suggest. I actually think this is a really important point that hasn't gotten enough attention yet in the litigation. I think you could, or if the administration could try to argue that courts have to read the Alien Enemy Act and the Alien Terrorist Removal Court statute together. Because usually, right, if two statutes are both potentially applicable, you try to let them coexist before you assume that there's a conflict. The problem there, and I think this is something that the Trumpies just missed, is that there's judicial review baked into the Alien Enemy Act too, right? Not the first section that everyone reads, but the third section, which is literally called Jurisdiction of U.S. Courts. And so, I have this, not very well tested theory that part of what happened here is that, folks read Litigation, which says the war termination question under the statute is not reviewable. And they assumed that that necessarily meant that the statute conferred mass summary removal power, and somehow missed that during World War II, there were literally hundreds of cases where federal courts reviewed whether particular individuals were, nationals of Germany or nationals of Italy. And Litigation doesn't call this into question at all. Like, I think this might have just been some really bad lawyering. And now they're trying to cover their, behinds by saying, no, of course it's the president's Article 2 power. That's not, no one has ever argued before that the president has inherent Article 2 power to remove folks without due process. That would just be, for lack of a better word, nuts.
Mm-hmm.
Query. If this is an invasion, doesn't that potentially trigger other parts of the Constitution that could allow the president to, for example, suspend habeas corpus, call forth the militia? So in other words, I hear what you're saying, but there is a path if they win on this, whatever the factual / legal question of whether this is an invasion, that could open the door for that kind of power. No?
It could. You'd have to sort of, squint really hard and maybe hold your breath to get to those other provisions too. I mean, so let's take the suspension clause, right? So the suspension clause is in Article 1. And, going all the way back to Chief Justice Taney in 1861, everyone assumes that it's Congress who suspends habeas corpus, not the president. Right. So even if somehow you had a judicial determination that whether or not it's an invasion is not reviewable, I think that's a problem for lots of reasons. I'm not sure that the next day Trump suspends habeas corpus. Right. There's a broader point here. And it's the reason why I sort of lose sleep over this litigation, which is the specific legal arguments aside. I mean, the real principle that I think this case is about is, who decides our fate? Right? Is it the president who decides our fate? Is it Congress who decides our fate? Or is it the courts who decide our fate? And it seems to me that when we're talking about removing people from the country where they're ending up in a Salvadorian prison, the courts would be issuing a rather self-defeating ruling. It would be sort of a self-inflicted wound for the courts to say, we have no ability to second guess this. And I even this Supreme Court, Asha, I would be shocked if that's where this ended.
Well, that gets to their own power and authority as a co-equal branch. And it seems like that if there's any lesson from the post 9/11 cases, that's one thing that they really don't want to give up.
And, and I think it's not for nothing that with all of the rhetoric out there where, Trump and his supporters are attacking federal judges, are calling them out by name, are, introducing impeachment resolutions in the House, it was Trump specifically singling out Chief Judge Boasberg that impelled Chief Justice Roberts to make a very, very rare and very pointed public statement last week, because I suspect Roberts, who, by the way, is like very close to Boasberg, understands exactly those implications in this case. And so, USAID funding, firing agency heads, cutting the Department of Education in half, like that's all a mess. But this is, a threat to judicial review in a way that I'm not sure that many of the other Trump cases so far have been.
Are we really that confident that this court is going to defend its own prerogative, even if that means, like, in its own powers, even if that means going against Donald Trump? And the reason I say that is, for example, essentially giving widespread immunity to the president of the United States and preventing the use of evidence in federal court of acts that were undertaken by the administration, I would think, does, at least in a certain respect, limit the power of the judiciary to review the decisions of the executive branch, and in many ways can be utilized by a rogue president or a president with bad intentions to do all sorts of things that would undermine provisions of the Constitution. So why wouldn't we see, in the end of the day, a 5-4 majority doing the same thing here?
It's a great question, Renato, and it keeps me up a lot.
Okay.
I'll say,
not crazy. Yeah,
I'm
not the only one.
I mean, the court has done this to ourselves, to themselves. I mean, I think that's part of the problem here. I guess to me, I can count to 5 in the other direction, right? And so I can count to 5 between the 3 Democratic appointees and Justice Barrett and Chief Justice Roberts. Even the very same Chief Justice Roberts who wrote the immunity decision, but who I think also understands at a very basic level what it would mean, not just to make it possible for Trump to win re-election, but to cut the courts out of the loop when it comes to reviewing second-term Trump's actions, namely, right, a third term. And I think Roberts understands that viscerally. I think Barrett understands that. I think what is horrifying to me is that I can't confidently count to 6. For this question. But, look at the USAID funding case, where, even though the court didn't do much in ruling against President Trump, it was still, it still ruled against Trump 5-4. I guess I see the Roberts statement from last week as him signaling to the district court judges out there, like, listen, when it comes to sort of pure rule of law stuff, we're going to have your back. And, at least for now, I have at least some confidence that he means it.
So how do we square that with what Renato just said with the immunity decision? Because we also have seen in the filings Trump making the claim, it's not the central claim, they're still hanging their hat on the statute, but that there is this inherent Article 2 authority to do this. In other words, we don't need no stinking statute. We could do this anyway. And if the argument is that it's a core, presidential power, it's not clear to me in light of the immunity decision, which I know talked about criminal liability, but was also extrapolating from other civil liability. Like, how far are they going to even go? I mean, I guess they would have to, I guess, first say, no, this isn't a core. Like, this is not completely within your power, and that's how they would get there.
Well, and you've already explained how they would do that, right? I mean, immigration has been a shared power going all the way back to the founding. The Alien Enemy Act was enacted by the 5th Congress, which was full of the same folks who helped to write the Constitution. And that statute is a congressional delegation of a heck of a lot of power to the president with judicial review, right? So the history and tradition here are very much against this being a core power. Listen, I mean, I can't say with like supreme confidence that this is going to happen, and that's a bit terrifying, and that is the Supreme Court's fault. But if there's one thing that I think this court would understand, even on a sort of cross-ideological basis, it's what the stakes are if they surrender the field. And it's one thing to say that the Article 2 powers are broader than we previously thought. It's something else altogether to say, and we have no role to play in reviewing their exercise. And even the immunity decision actually carved out a heck of a lot of power for the courts to play, because it would be the courts who are drawing the relevant lines. Right? This is a step past that. This is saying, oh, we have no role to play in deciding who we're at war with and deciding who can be put on a plane and whisked off to El Salvador. We will be in deep trouble if I'm wrong, but I feel more confident there than I did about the immunity case.
I just want to punctuate two things rather remarkable about the latest exchange or two that we've had here. One is, a lot of folks who are listening to our podcast or viewing our podcast on YouTube or elsewhere, they are eager for someone to fight back, for someone to stop Trump, for someone to be looking over his activities to curtail him, to slow him down. The only entity that has been able to do that are the courts. Yeah. I mean, the judicial system is the only one that has been able to do it. And what we're basically coming down to here is we think we may have a 5-4 majority, but if somebody dies or whatever circumstances, or retires, or just has a change of heart, maybe not, and maybe there'll be no check whatsoever to, as you put it, a third term, people being able to be shipped off into concentration camps or whatever, foreign prisons. That's very, very concerning news.
So, I mean, I guess another way of putting this is, I think the rule of law is holding, but it's holding not by nearly as much as I wish it were. And I don't like the term constitutional crisis because I have no idea what is true if we're in one versus if we're not in one. But I think we're in an institutional crisis, and an institutional crisis that is not brand new. I mean, Congress has been abdicating power for decades, but that has reached its zenith with Trump, or its nadir, depending on your perspective. If anything, though, I mean, guys, this is why I guess I have more faith in the courts. I, who have been a very visible public critic of this Supreme Court for a long time, I would still rather have the fate of our democracy being up to John Roberts and Amy Coney Barrett than being up to Donald Trump, J.D. Vance, and Stephen Miller. And, that's not exactly like a great answer, but I have a lot more faith in Roberts and Barrett to sort of, not to draw the lines, guys, where I think they ought to be drawn, or where I think we would prefer them to be drawn, or where I think we'd be better for them to be drawn, but at least to draw them somewhere where what we have is still a democracy and a system that looks like it follows the rule of law.
Well, I just say one very brief thing there is, in addition to who they are, because there's also the fact that the court has much more limited power to start with. So them being able to assert some sort of counterweight has some value here.
I agree.
So speaking of that, where could this go from here? So, as you noted, the planes landed in El Salvador. So there's a bunch of people in an El Salvadorian prison being tortured right now. And we don't know who they are and whether they're actually members of this class. So let's take the two threads that you referred to. Let's take the actual TRO threads. If the TRO is upheld, I guess I'm really worried about the people who are in the prison right now.
Yeah.
Like, I would like them to come back until we figure this out. Like, it keeps me up at night. Like, what is happening to them? I was a Latin American studies scholar as an undergrad. This, even our worst prisons in the United States, I'm sure, do not compare to the kinds of things that you can find in Central and South America, given their history. So, what happens to those people?
Well, so the New York Times reports that some of them have actually already been brought back, which is a remarkable concession on the Trump administration's part, if that's true. I don't know what happens. I think there will be efforts to try to get the federal courts, whether it's Judge Boasberg or in other litigation, to order the government to take steps to bring back as many of those folks as possible. But this is why the TROs are so important. I mean, this is why pre-removal litigation is so critical in this space. And, you guys last week talked about Mahmoud Khalil in his case, because removal is a difficult bell to unring. And so I think two things can be true, right? One, the future of the TRO litigation is really, really important in making sure no one else ends up in an El Salvadorian prison. And two, it's not going to be fully effective, even if it succeeds, in getting back the people who were sent there. That at least for some of those folks, I fear that the ship has sailed. And that's a problem unto itself. In the, terrifying moral calculus of 2025, that is probably not quite as systemic a problem as if this is allowed to continue.
And then what about the defiance of court orders? If the court finds, if Judge Boasberg finds that they willfully allowed these planes to go even after his order, and I think it seems pretty settled that even if it's a verbal order and they heard it and it's in the transcript, it seems like that's a order. What do you see potentially happening, and what is your opinion on where the Trump administration goes with compliance with court orders more generally? Because I think you have been, we've had some exchanges in groups where I've been like, this is 1973 Chile, which I keep saying because I feel like we're pretty much there. Black van rolling up in the middle of the night does not seem to me to be so far away. But you seem to be more optimistic about the compliance issue. And I guess the fact that, as you just noted, them bringing back some of these people may support your view more than mine.
Well, I mean, as ever, I think the answer is probably somewhere in the middle, right? That, I think I've analogized what the Trump administration is doing right now to the velociraptors in Jurassic Park, right? That they're testing the fences. Mm-hmm. And that's not the same thing as like running over the fences, because, right, it's probing, it's seeing what they can get away with, it's seeing what kind of pressure they can bring to bear. And, it also gives them plausible deniability, where when congressional Republicans say, what the heck are you doing? And they say, no, we're not doing anything. Right? Outright defiance is something else entirely. And I guess, my suspicion is that outright defiance is not the end game here, because that's the quickest way to lose just enough Republican support in Congress, where all of a sudden Congress will stop acquiescing in everything. The problem is, how do the courts push back? So the mistake in Jurassic Park is when the velociraptors tested the fences, nothing was done to reinforce the fences. Right? And I think the reinforcements are what's needed. And that's where John Roberts' statement comes in. I mean, that's part of what that is. Getting Trump to say on Fox News, no, of course, we're not going to defy court orders. Like, those things have value, even if they're sort of modest. The administration actually not doing various things that it would be doing if it really didn't want to comply. Again, like, after there haven't been more flights, right, to El Salvador. And so, I think this is dangerous. I think it is more resistance to the courts than we've ever seen from a president. And I still think we're not at the real sort of point of no return, because we're starting to see sort of efforts from the institutions to actually push back at least a little. We need more of that. And that's where I think this case becomes so important.
Well, on that, can I just ask one more question? I think you're right. It does seem, though, that there is a sort of compliance, but more as a kabuki dance, right? I mean, they were called back in to answer to Judge Boasberg about what, like, who knew what when kind of thing. Yep. And it just seemed like a big F you to the judge, to me.
To a point. But again, I mean, the Boasberg is not, new to this. And so, they can only keep up that dance for so long before someone under penalty of perjury is going to have to swear to what happened. Right. And before sanctions are going to be available, maybe not contempt, because that risks all the questions about who enforces contempt sanctions against the federal government. But, bar referrals. I mean, overnight, right? Maybe every single lawyer who puts their name on one of these pleadings in the DC courts gets referred to the DC bar for disciplinary action. I mean, if we really went like all the way down the rabbit hole into what courts can do when the government is not fully complying, courts actually have a heck of a lot of ability to put both indirect and direct pressure on the government, to put both indirect and direct pressure on government lawyers, to be honest about what's happening, to face sanction if they're not honest, and then when they are honest, right, to punish the government if it's not actually doing what it's supposed to do. And Asha, you may say, or folks may say, well, they can't bring these guys back from El Salvador, and that may be right, but there are plenty of other ways in which the federal government depends upon the federal courts to do its job. And if the federal courts all of a sudden say, listen, we're not going to help you unless you help us, that's a threat that would have some real teeth.
It's interesting. I don't know how that would actually occur in practice. It's very interesting, though. I will tell you, these are such big problems. And it's such I would say it's a conversation that I really wish we weren't having.
Amen. And it's a conversation that everyone who's responsible for provoking should be forever repudiated for provoking. I mean, I am horrified every day by how little consensus there is, even among folks who should know better on the right, that this is all very dark. And how much they're willing to forgive the darkness because they like in the short term some of the headlines they're seeing. Like, that's just, I had held out the naive view that we were at least a little bit smarter than that, and it turns out, nope, we're really not.
On that note,
I usually end things like positively and optimistically.
Well, how's this? Maybe sometime soon we'll have you back on to go down that rabbit hole of what all the things that the courts can do to bring pressure. Because I do feel like it could be helpful, because I think there is a sense of despair and impotence right now that, nothing matters and everything is lost. And I do think we need to have, even if it's small hopes and small wins, like really understand what our government can do. Yeah. Even in this situation.
Well, and just, and I'll say, I think it's really important to make this point. Like, we may not be seeing all of the court orders like going into full operation, but I don't know how anyone can look at the first 2 months of the Trump administration and come away with the view that the courts weren't a major obstacle to a lot of what Trump wants to do. They absolutely have been. We still have birthright citizenship because of the courts, right? Things could have been so much worse, but for the courts. And so, to me, the optimism here is that, yes, like, this has been rough and a lot of things have been broken, and it's going to be very hard to fix many of those things. But the courts are doing a remarkable job in being that last guardrail. They can't, I think, sustain that indefinitely. They shouldn't have to sustain it indefinitely. But, for the lawyers especially, I actually think it's been a remarkable story of successful litigation, and not the sort of the quick and immediate demise of the rule of law.
Okay, that's a better note to end on.
Okay.
Thank you so much.
And guys, and the fact that they're attacking the judges. I mean, the fact that going after these judges has become an organizing principle of the PR campaign from the White House, I think is all the evidence you need that the judges are a real obstacle at this point.
Mm-hmm. I agree.
All right, I'm done. Sorry.
No, that's great. Thank you so much, Steve.
Thanks a lot.
It really helped unpack a lot of the craziness, and I think we'll see what happens at the next hearing, and I'm sure we'll have you back on soon.
Yeah, your voice is so important, by the way, Steve.
Everybody needs to read Steve's Substack. It is so amazing. I truly cannot believe you write that every single week, because it's like so. He has historical context. He really unpacks all of the major legal issues that are going on in such an accessible way, and it's an indispensable resource for me, and I think for Renato also.
Thanks, guys. Well, I have this really unfortunate quality, which is I write when I'm angry.
Good.
And that's the secret. You're always angry.
I mean, these days. Thank you, guys.
Thanks.
Awesome.
Bye. So, Asha, before we go, are you watching March Madness at all?
Not really. After I really only watch when Princeton makes it into the tournament.
Oh, I was wondering how you were going to end that sentence because into the tournament, okay.
I know
Much further than that.
Well, they've had some upsets in the past, and
yes,
yeah, right. Like a couple of years ago, they even made it to the second round. And anyway, that's usually the only time. I mean, I enjoy college basketball if it's on, and I might watch it, or if there's when it gets to the finals, I'll sometimes watch it. If there is a sports tournament I watch, college basketball would be it.
It's interesting. Yeah, I mean, obviously, March Madness is a big deal. I feel like everyone pays attention to it, even if you're not a super college sports fan. I'm more of a pro sports fan because I went to colleges that weren't that great at sports. No offense to anyone in my all the alma maters, but I grew up in a sports town. But I think, one thing I think is super interesting right now is like it used to be that like your March Madness bracket pool is the only way you could bet on sports if you didn't live in Nevada. And now like everyone's betting all over the place. If you watch TV, if you watch sports, you'll see every other TV ad is for a different sports betting outlet. It's exploding. It's becoming such a big thing right now.
So like FanDuel?
FanDuel and DraftKings are two big names, yes.
Are you impressed that I know that?
Yeah, I'm actually, I'm not, because if you watch sports, like every other ad is a FanDuel.
Well, no, but okay, I know that not because I watch sports, but because I had a friend who worked for FanDuel, so she was the one who told me about it.
Oh, got it. Well, it's like it used to be like you'd watch sports and every ad would be like a beer ad, and they still are there. It's not like people don't drink beer anymore or eat pizza, but like there's like a lot of sports betting ads, and they're integrated in with the networks, and the networks are behind them. It's like a big change right now. I mean, John Oliver just did a big segment about it, talking about it because it's a societal shift. Now they're talking about, and I think there will be, financial instruments that you can use to just like literally trade it, and in moments, blink of an eye, you can be trading in and out of all your sports betting positions. So it's getting bigger and bigger.
How does this work with like gaming laws?
So gaming
among the
laws are,
states?
gaming laws are state by state. There's
Yeah.
a battle right now between
Okay.
the financial folks who are deregulating and allowing this, putting regulatory frameworks to allow that, and the state regulators, and by the way, Native American tribes who have their own views. So it's like I don't want to get too serious here at the end, but no, there'll be a legal battle in addition to a societal shift.
Yeah, well, maybe we should at some point do a block. So are you a block on the legal stuff? Because I think that could be interesting. And maybe a nice break from some of the other crap that we talk about all the time. But are you betting?
I do not. And it's funny because many of my clients do. Sometimes I give legal advice about some of the regulation regarding that stuff. And I just do not do it because I think I'm somebody who I don't want to ever get too into it and spend more money than I can. I casinos, I'll play poker because I enjoy playing poker, but even there, if I'm playing like anything but a set tournament where there's like a set entry fee, I'll like try to cap exactly how much I bet. I don't know if you do that when you go to like a table.
I don't gamble. Like I don't find any joy in that at all. I don't mind going and watching. Like I've gone to like Mohegan Sun and Foxwoods or whatever, and I'll sit and watch people play blackjack or, and I get excited for them if they win. But I just like, to me, I would just hate to lose money. Like it would suck. It just feels like a dumb thing to lose money on, even though the upside is there's a lot of upside. So I think if I were to do it, I would have to just kind of really just get in the mental space that I was going to spend X amount of money on this experience. And that way, even if I lost it all, like to find some value in the experience. But to me, it's just, I don't feel like it really has that much value to me personally. I'd rather spend it on something else.
That's why I do poker tournaments, because when I do poker tournaments, I've done a lot of those. Even when I did my cruise over the holidays, I did a couple of them on the boat. I enjoy it because there's a set entry fee. I know what I'm paying. I'm putting $150 in or whatever it is, and it's entertainment, and I'm competing against everyone else. I'm trying to beat them at a game of skill. There's obviously chance element to it as well, but it's about managing risk. And so
have you read Annie Duke's book? No, is it No or Quit? No or Quit? The power.
No, but it's about knowing when they quit.
It's the title. I feel bad in case she listens to our podcast. It's either No or Quit. I'm not sure, but then it's the power of knowing when to walk away. And she basically draws on, her poker strategies, but kind of zooms out to talk about decision making more generally. That, all these like cognitive fallacies that we have in life in making decisions, whether it's about changing jobs or leaving relationships and all of these things. And one that like always sticks with me is she says, when you walk away from something at the right time, it always feels like you're walking away too early.
That's interesting. That's really profound.
Like, because people will wait, because they feel like they need to wait until they know for sure. But usually if you wait until that point, whatever the situation is, it's often too late and you wish you had done it earlier. When you leave at the right time, it feels like you're leaving or you're doing it too soon.
That's really interesting. One thing I've loved about playing poker is it's definitely gotten me into game theory.
Mm-hmm.
And if you really play poker, even I'm an amateur level, you get to learn that stuff. And I use that when I discuss things with clients, when I'm trying to do strategy about a litigation. I think it has so much application in life, those lessons.
Well, check out her book.
Absolutely. I will.